What is eminent domain? Under fundamental powers of the state. Eminent domain is the right or power of a sovereign state to appropriate private property to particular uses to promote public welfare. It is an indispensable attribute of sovereignty, a power grounded in the primary duty of government to serve the common need and advance the general welfare. The power of eminent domain is inseparable in sovereignty, being essential to the existence of the state and inherent in government. But the exercise of such right is not unlimited, for two mandatory requirements should underlie the government's exercise of the power of eminent domain, namely, 1. That it is for a particular public purpose, and 2. That just compensation be paid to the property owner. These requirements partake the nature of implied conditions that should be complied with to enable the condemnor to keep the property expropriated. National Transmission Corporation versus Auroville Development Corporation, GR 223366, August 2017. Requisites of taking. 1. The expropriator must enter a private property. 2. The entrance into private property must be for more than a momentary period. 3. The entry into the property should be under warrant or color of legal authority. 4. The property must be devoted to a public use or otherwise informally appropriated or injuriously affected. And 5. The utilization of the property for public use must be in such a way as to oust the owner and deprive him of all the beneficial enjoyment of the property. National Transmission Corporation versus Auroville Development Corporation. What is just compensation? Just compensation is the sum equivalent to the market value of the property, broadly described as the price fixed in open market by the seller in the usual and ordinary course of legal action or competition, or the fair value of the property as between one who receives and who desires to sell it, fixed at the time of the actual taking by the government. The word just is used to emphasize the meaning of the word compensation, so as to convey the idea that the equivalent to be rendered for the property to be taken should be real, substantial, full, and ample. The nature and character of the land at the time of taking is thus the principal criterion in determining just compensation. All the facts as to the condition of the property and its surroundings, as well as its improvements and capabilities, must be considered. The justness of the compensation can only be attained by using reliable and actual data as basis in fixing the value of the condemned property. Paz E. Rebadula et al. Versus Republic, GR 222159. Is the valuation of property in eminent domain a judicial function? The valuation of property in eminent domain is essentially a judicial function which cannot be vested in administrative agencies. The executive department or the legislature may make the initial determination. But when a party claims a violation of the guarantee in the Bill of Rights that private property may not be taken for public use without just compensation, no statute, decree, or executive order can mandate that its own determination shall prevail over the court's findings. Much less can the courts be precluded from looking into the justness of the decreed compensation. Land Bank of the Philippines versus Eugenio Dalota. Is there a limit to the period for landowners to assert their right to just compensation by the executive branch? There is no basis for the executive branch to limit the period for landowners to assert their right to just compensation under RA 6657, considering that RA 6657 does not provide a limit on the period within which a landowner can file a petition for the determination of just compensation, and considering further that the right to just compensation is a constitutional right, there is no basis for the executive branch to limit the period for landowners to assert their right to just compensation under this act. Any attempt to do so should be struck down for being outside the constitutional confines of the eminent domain powers of the state. Under Bill of Rights, in order that a particular act may not be impugned as violative of the Due Process Clause, there must be compliance with both the substantive and the procedural requirements thereof. Substantive due process refers to the intrinsic validity of a law that interferes with the rights of a person to his property. Procedural due process, on the other hand, means compliance with the procedures or steps, even periods, prescribed by the statute, in conformity with the standard of fair play and without arbitrariness on the part of those who are called upon to administer it. Alliance for the Family Foundation Philippines et al. Versus Honorable Janet Guerin, GR 217872 and 221866. Is the right to security separate and distinct from the right to life? The right to security is separate and distinct from the right to life. The right to life guarantees essentially the right to be alive, upon which the enjoyment of all other rights is preconditioned. On the other hand, the right to security is a guarantee of the secure quality of life, that is, the life to which each person has a right, is not a life lived in fear that his person and property may be unreasonably violated by a powerful ruler. Mayor William Mamba et al. Versus Leomar Bueno, GR number 191416, 2017. Do law enforcers need to personally witness the commission of a crime to indicate that the person sought to be arrested committed it? No. Law enforcers need not personally witness the commission of a crime. However, they must have personal knowledge of facts and circumstances indicating that the person sought to be arrested committed it. Rule 113, Section 5, letter B of the Rules of Court pertains to a hot pursuit arrest. The rule requires that an offense has just been committed. It connotes immediacy in point of time. That a crime was in fact committed does not automatically bring the case under this rule. An arrest under Rule 113, Section 5, letter B of the Rules of Court entails the time element from the moment the crime is committed up to the point of arrest. Mario Veridiano versus People of the Philippines. What is stop and frisk search? Stop and frisk search is defined as the act of a police officer to stop citizen on a street, interrogate him, and pat him for weapons or contraband. Thus, the allowable scope of a stop and frisk search is limited to a protective search of outer clothing for weapons. Although a stop and frisk search is a necessary law enforcement measure specifically directed towards crime prevention, there is a need to safeguard the right of individuals against unreasonable searches and seizures. Mario Veridiano versus People. Does routine inspection give law enforcers carte blanche to perform warrantless searches? A checkpoint search is a variant of a search of a moving vehicle. The extent of routine inspections must be limited to a visual search. Routine inspections do not give law enforcers carte blanche to perform warrantless searches. Checkpoints per se are not invalid. They are allowed in exceptional circumstances to protect the life of individuals and ensure their safety. They are also sanctioned in cases where the government's survival is in danger. Considering that routine checkpoints intrude on a motorist's right to free passage, or to a certain extent, they must be conducted in a way least intrusive to motorists. Mario Veridiano versus People. Can an extensive search be conducted on a vehicle at a checkpoint when law enforcers have probable cause to believe that the vehicle's passengers committed a crime or when the vehicle contains instruments of an offense? Yes. An extensive search may be conducted on a vehicle at a checkpoint when law enforcers have probable cause to believe that the vehicle's passengers committed a crime or when the vehicle contains instruments of an offense. Extensive searches are permissible only when they are founded upon probable cause. Any evidence obtained will be subject to the exclusionary principle under the Constitution. Mario Viridiano versus People. One of the constitutional requirements for the validity of a search warrant is that it must be issued based on probable cause, which under the rules must be in connection with one specific offense to prevent the issuance of a scattershot warrant. In search warrant proceedings, probable cause is defined as such facts and circumstances that would lead a reasonable, discreet, and prudent man to believe that an offense has been committed, and that the objects sought in connection with the offense are in the place sought to be searched. People versus Amador, Pastrana, and Rufina Abad. February 21, 2018, GR 196045. What is the reason behind the constitutional requirement of reasonable particularity of description of the things to be seized? The constitutional requirement of reasonable particularity of description of the things to be seized is primarily meant to enable the law enforcers serving the warrant to 1. Readily identify the properties to be seized and thus prevent them from seizing the wrong items, and 2. Leave said peace officers with no discretion regarding the articles to be seized and thus prevent unreasonable searches and seizures. It is not, however, required that the things to be seized must be described in precise and minute detail as to leave no room for doubt on the part of the searching authorities. One of the tests to determine the particularity in the description of objects to be seized under a search warrant is when the things described are limited to those which bear direct relation to the offense for which the warrant is being issued. People versus Amador Pastrana and Rufina Abad. Does a laborer lose his or her right to freedom of expression upon employment? No. A laborer does not lose his or her right to freedom of expression upon employment. This is a political right essential to man's enjoyment of his or her life, to his or her happiness, and to his or her full and complete fulfillment. While the Constitution and the courts recognize that employers have property rights that must also be protected, the human rights of laborers are given primacy over these rights. Property rights may prescribe, human rights do not. Charlie Hubila et al. Versus HSY Marketing, GR 207354, January 10, 2018. Does the state still recognize the inherent right of the people to have some form of belief system? Yes. The state still recognizes the inherent right of the people to have some form of belief system, whether such may be belief in a supreme being, a certain way of life, or even an outright rejection of religion. Our very own Constitution recognizes the heterogeneity and religiosity of our people, as reflected in Imbong versus Ochoa Jr. As follows, at the outset, it cannot be denied that we all live in a heterogeneous society. It is made up of people of diverse ethnic, culture, and religious beliefs and backgrounds. History has shown us that our government, in law and in practice, has allowed these various religious, cultural, social, and racial groups to thrive in a single society together. It has embraced minority groups and is tolerant towards all, the religious people of different sects and the non-believers. The undisputed fact that is our people generally believe in a deity, whatever they conceived him to be, and to who they called for guidance and enlightenment in crafting our fundamental law. In letter of Tony Valenciano, holding of religious rituals at the Hall of Justice building in Quezon City. The right to religious profession and worship has twofold aspect: freedom to believe and freedom to act on one's belief. The first is absolute as long as the belief is confined within the realm of thought. The second is subject to regulation where the belief is translated into external acts that affect the public welfare. Same letter. Allowing religion to flourish is not contrary to the principle of separation of church and state. In fact, these two principles are in perfect harmony with each other. The state is aware of the existence of religious movements whose members believe in the divinity of Auroville, yet it does not implement measures to suppress the said religious sects. Such inaction or indifference on the part of the state gives meaning to the separation of church and state, and at the same time recognizes the religious freedom of the members of these sects to worship their own supreme being. As pointed out by Judge Lutero, the Roman Catholics expressed their worship through the Holy Mass, and to stop these would be tantamount to repressing the right to free exercise of their religion. Our Muslim brethren, who are government employees, are allowed to worship their Allah, even during office hour inside their own offices. The Seventh-day Adventists are exempted from rendering Saturday duty because their religion prohibits them from working on a Saturday. Even Christians have been allowed to conduct their own Bible studies in their own offices. All these have been allowed in respect of the workers' right to the free exercise of their religion. On the same letter. Does the student religious obligations take precedence over his academic responsibilities? And is it in consonant with the constitutional guarantee of free exercise and enjoyment of religious worship? Yes. The Commission on Higher Education, CHED, imposed a positive duty on all higher education institutions to exempt students as well as faculty members from academic activities in case such activities interfere with their religious obligations. Denmark Valmores versus Dr. Christina Achacoso, GR 217453. What is void for vagueness doctrine? Void for vagueness doctrine, as statute or act, suffers from the defect of vagueness when it lacks comprehensible standards that men of common intelligence must necessarily guess at its meaning and differs as to its application. It is repugnant to the Constitution in two respects. 1. It violates due process for failure to accord persons, especially the parties targeted by it, fair notice of the conduct to avoid, and 2. It leaves law enforcers unbridled discretion in carrying out its provisions and becomes an arbitrary flexing of the government muscle. In the case of Spark et al. Versus Quezon City, GR 225442, August 8, 2017, the Supreme Court ruled that petitioners' invocation of the void of vagueness doctrine is improper, considering that they do not properly identify any provision in any of the curfew ordinances which, because of its vague terminology, fails to provide fair warning and notice to the public of what is prohibited or required so that one may act accordingly. The void of vagueness doctrine is premised on due process considerations which are absent from this particular claim. Is the presumption of regularity stronger than the presumption of innocence in favor of the accused? No, the presumption of regularity cannot be stronger than the presumption of innocence in favor of the accused. The presumption of regularity of performance of official duty stands only when no reason exists in the records by which to doubt the regularity of the performance of official duty. Applied to dangerous drugs cases, the prosecution cannot rely on the presumption when there is a showing that the apprehending officers failed to comply with the requirements laid down in Section 21, and in any case, the presumption of regularity cannot be stronger than the presumption of innocence in favor of the accused. Otherwise, a mere rule of evidence will defeat the constitutionally enshrined right to be presumed innocent. People versus Richel Luna, or Ricael Luna, GR 219164, March 21, 2018. An accused's right to have a speedy, impartial, and public trial is guaranteed in criminal cases by Section 14, Number 2, Article 3 of the 1987 Constitution. This right to a speedy trial may be defined as one free from vexatious, capricious, and oppressive delays, its salutary objective being to assure that an innocent person may be free from the anxiety and expense of a court litigation, or if otherwise of having his guilt determined within the shortest possible time compatible with the presentation and consideration of whatsoever legitimate defense he may interpose. In the determination of whether the defendant has been denied such right, the following factors may be considered and balanced. A. The length of delay. B. The reason for the delay. C. The assertion or failure to assert such right by the accused. And D. The prejudice caused by the delay. Angelito Magno versus People of the Philippines, GR 230657, March 14, 2018. The Supreme Court expounded that the guarantee of speedy disposition under Section 16 of Article 3 of the Constitution applies to all cases pending before all judicial, quasi-judicial, or administrative bodies. Hence, whether or not the fact-finding investigation was separate from the preliminary investigation conducted by the Office of the Ombudsman should not matter for purposes of determining if the respondent's right to the speedy disposition of their cases had been violated. Remola versus Sandiganbayan. Under Citizenship Republic Act number 9225 contains no provision stating that it may be applied retroactively as regards natural-born citizens who became naturalized citizens of a foreign country prior to the effectivity of the said law. Only those falling under the second paragraph of RA 9225, that is, natural-born citizens who became naturalized citizens of a foreign country after the effectivity of the said law, shall be considered as not to have lost their Philippine citizenship. Moreover, to consider that the reacquisition of Philippine citizenship retroacts to the date it was lost would result in an absurd scenario where a Filipino would still be considered a Philippine citizen when in fact he had already renounced his citizenship. In the case of Vivian K. Tan versus Vincent Bingbong Crisologo, GR number 193993, November 8, 2017. During the time petitioner lost her Philippine citizenship, RA 9225 was not yet enacted and the applicable law was still Commonwealth Act 63. Under this law, both the renunciation of the Philippine citizenship and the acquisition of a new citizenship in a foreign country through naturalization are grounds to lose Philippine citizenship. Is the separation of powers doctrine the backbone of our tripartite system of government? The principle of separation of powers referred to the constitutional demarcation of the three fundamental powers of government. It means that the Constitution has blacked out with deft strokes and in bold lines allotment of power to the executive, the legislative, and the judicial departments of the government. To the legislative branch of government through Congress belongs the power to make laws. To the executive branch of government through the President belongs the power to enforce laws, and to the judicial branch of government through the court belongs the power to interpret laws. Alexander Padilla et al. Versus Congress of the Philippines et al. GR numbers 231671 and 231694. The separation of powers among the three co-equal branches of our government has erected an impregnable wall that keeps the power to promulgate rules of pleading, practice, and procedure within the sole province of the Supreme Court. The other branches trespass upon this prerogative if they enact laws or issue orders that effectively repeal, alter, or modify any of the procedural rules promulgated by the court. The power to promulgate rules of pleading, practice, and procedure is now the Supreme Court's exclusive domain and no longer shared with the executive and legislative department. Salvador Estipona Jr. versus Honorable Frank Lobrigo, GR number 226679. The fundamental law of the land provides that the state cannot be sued without its consent. It is a fundamental postulate of constitutionalism flowing from the juristic concept of sovereignty that the state, as well as its government, is immune from suit unless it gives its consent. The rule in any case is not absolute, for it does not say that the state may not be sued under any circumstances. The doctrine only conveys that the state may not be sued without its consent. Its clear import, then, is that the state may at times be sued. Suits filed against government agencies may either be against incorporated or unincorporated agencies. In case of incorporated agencies, its suability depends upon whether its own organic act specifically provides that it can sue and be sued in court. Madagbuisan et al. Versus Commission on Audit et al. GR 212376. The doctrine of non-suability cloths the Department of Public Works and Highways, DPWH, from being held responsible for alleged damages it performed in consonance with its mandated duty. As the state's engineering and construction arm, the DPWH exercises governmental functions that effectively insulate it from any suit, much less from any monetary liability. In this case, nowhere does it appear in the petition that the state has given its consent, expressly or impliedly, to be sued before the courts. The failure to allege the existence of the state's consent to be sued in the complaint is a fatal defect, and on this basis alone should cause the dismissal of the complaint. The Speaker of the House of Representatives shall be elected by a majority vote of its entire membership. The House of Representatives may decide to have officers other than the Speaker, and that the method and manner as to how these officers are chosen is something within its sole control. While the Constitution is explicit on the manner of electing Speaker of the House of Representatives, it is, however, dead silent on the manner of selecting the other officers of the lower house. All that the Charter says is that each house shall choose such other officers as it may deem necessary. As such, the method of choosing who will be such other officers is merely a derivative of the exercise of the prerogative conferred by the aforequoted constitutional provision. Therefore, such method must be prescribed by the House of Representatives itself, not by the court. Representative Teddy Baguillet Jr. et al. Versus Speaker of Pantaleon D. Alvarez, GR 227757, 25 July 2017. The question on whether Congress is constitutionally mandated to convene in joint session, even to vote jointly to revoke the President's declaration or suspension, the Congress is not constitutionally mandated to convene in joint session except to vote jointly to revoke the President's declaration or suspension. In this case, the issue is whether or not under Article 7, Section 18 of the 1987 Constitution, it is mandatory for the Congress to automatically convene in joint session in the event that the President proclaims a state of martial law and or suspends the privilege of the writ of habeas corpus in the Philippines or any part thereof. The court answers in the negative. The Congress is not constitutionally mandated to convene in joint session except to vote jointly to revoke the President's declaration or suspension. Therefore, whether or not to hold a joint session under such circumstances is completely within the discretion of the Congress. Alexander Padilla et al. Versus Congress of the Philippines et al. 231671. Executive Department. The Judicial and Bar Council, JBC, cannot impair the President's power to appoint members of the judiciary and his statutory power to determine the seniority of the newly appointed Sandiganbayan Associates Justices. As long as in the end, the President appoints someone nominated by the Judicial and Bar Council, JBC, the appointment is valid, and he, not the JBC, determines the seniority of appointees to a collegiate court. As the court pronounced in its decision dated November 29, 2016, the power to recommend of the JBC cannot be used to restrict or limit the President's power to appoint as the latter's prerogative to choose someone whom he or she considers worth appointing to the vacancy in the judiciary, still paramount. The declaration of the court that the clustering of nominees by the JBC for the simultaneous vacancies that occurred by the creation of 6 new positions of Associate Justice of the Sandiganbayan is unconstitutional was only incidental to its ruling that President Aquino is not bound by such clustering in making his appointments to the vacant Sandigan Associate Justice posts. Honorable Philip Aguinaldo et al. Versus President Benigno Aquino, February 21, 2017. Military powers of the President. 1. Calling out power. The President may resort to his extraordinary power whenever it becomes necessary to prevent or suppress lawless violence, invasion, or rebellion. The actual use to which the President puts the armed forces is not subject to judicial review. This power fully discretionary to the President, the only limitations being that he acts within permissible constitutional boundaries or in a manner not constituting grave abuse of discretion. Number 2, power to suspend the privilege of the writ of habeas corpus. And 3, power to declare martial law. The extraordinary powers of suspending the privilege of the writ of habeas corpus and or declaring martial law may be exercised only when there is actual invasion or rebellion and public safety requires it. The powers to declare martial law and to suspend the privilege of the writ of habeas corpus involve curtailment and suppression of civil rights and individual freedom. Thus, the declaration of martial law serves as a warning to citizens that the executive department has called upon the military to assist in the maintenance of law and order. And while the emergency remains, the citizens must, under pain of arrest and punishment, not act in a manner that will render it more difficult to restore order and enforce the law. Unlike the calling out power, these two powers of the President are subject to the veto powers of the Supreme Court and Congress. Representative Edsel Lagman et al. Versus Honorable Salvador Medial Dia et al. Tier 231658, 231771, and 231774, July 4, 2017. What is the doctrine of contemporaneous construction? Under the doctrine of contemporaneous construction, the framers of the 1987 Constitution are presumed to know the prevailing jurisprudence at the time they were drafting the Constitution. Thus, the phrase sufficiency of factual basis in Section 18, Article 7 of the Constitution should be understood as the only test for judicial review of the President's power to declare martial law and suspend the privilege of the writ of habeas corpus under Section 18, Article 7 of the Constitution. The court does not need to satisfy itself that the President's decision is correct. Rather, it only needs to determine whether the President's decision has sufficient factual basis. In determining the sufficiency of the factual basis of the declaration and or the suspension, the Supreme Court should look into the full complement or totality of the factual basis and not piecemeal or individually. Neither should the court expect absolute correctness of the facts stated in the proclamation and in the written report, as the President could not be expected to verify the accuracy and veracity of all facts reported to him, due to the urgency of the situation. To require precision in the President's appreciation of facts would unduly burden him and therefore impede the process of his decision-making. Such a requirement will practically necessitate the President to be on ground to confirm the correctness of the report submitted to him within a period that only the circumstances obtaining would be able to dictate. The parameters of determining the sufficiency of factual basis are as follows: 1. Actual rebellion or invasion. 2. Public safety requires it. And the first two requirements must concur. And 3. There is probable cause for the President to believe that there is actual rebellion or invasion. The Constitution also grants the President the discretion to determine the territorial coverage of martial law and the suspension of the privilege of the writ of habeas corpus. He may put the entire Philippines or only part thereof under martial law. Another reason why the territorial scope of martial law should not necessarily be limited to the particular vicinity where the armed public uprising actually transpired is because of the unique characteristic of rebellion as a crime. The crime of rebellion consists of many acts. It is a vast movement of men and a complex net of intrigues and plots. Acts committed in furtherance of rebellion, though crimes in themselves, are deemed absorbed in one single crime of rebellion. Besides, the President's duty to maintain peace and public safety is not limited only to the place where there is actual rebellion. It extends to other areas where the present hostilities are in danger of spilling over. The initial declaration of martial law and or suspension of the writ of habeas corpus is determined solely by the President, while the extension of the declaration and or suspension, although initiated by the President, is approved by Congress. Representative Edsel Lagman et al. Versus Honorable Salvador Medial Dia et al. Yours 231658. Presidential appointees come under the direct disciplining authority of the President pursuant to the well-settled principle that in the absence of a contrary law, the power to remove or to discipline is lodged in the same authority in whom the power to appoint is vested. Having the power to remove or to discipline presidential appointees, therefore, the President has the corollary authority to investigate them and look into their conduct in office. Thus, Petitioner Bakuli, as a presidential appointee, came under the disciplinary jurisdiction of the President in line with the principle that the power to remove is inherent in the power to appoint. As such, the DAR Secretary held no disciplinary jurisdiction over him. Francisco T. Bakuli versus Office of the President, GR numbers 188681 and 201130, March 8, 2017. What is the doctrine of qualified political agency? Under this doctrine, which recognizes the establishment of a single executive, all executive and administrative organizations are adjuncts of the executive department. The heads of the various executive departments are assistants and agents of the chief executive, and except in cases where the chief executive is required by the Constitution or law to act in person on the exigencies of the situation, demand that he act personally. The multifarious executive and administrative functions of the chief executive are performed by and through the executive departments, and the acts of the secretaries of such departments, performed and promulgated in the regular course of business, are, unless disapproved or reprobated by the chief executive, presumptively the acts of the chief executive. Although the powers and functions of the chief executive have been expressly reposed by the Constitution in one person, the President of the Philippines, it would be unnatural to expect the President to personally exercise and discharge all such powers and functions. Somehow, the exercise and discharge of most of these powers and functions have been delegated to others, particularly to the members of the Cabinet, conformably to the doctrine of qualified political agency. Francisco Bakuli versus Office of the President. May the President be sued during his tenure or actual incumbency? No, the President may not be sued during his tenure or actual incumbency, and there is no need to expressly grant such privilege in the Constitution or law. This privilege stems from the recognition of the President's vast and significant functions, which can be disrupted by court litigations. It will degrade the dignity of the high office of the President, the head of state, if he can be dragged into court litigations while serving as such. Furthermore, it is important that he be freed from any form of harassment, hindrance, or destruction to enable him to fully attend to the performance of his official duties and functions. Unlike the legislative and judicial branch, only one constitutes the executive branch, and anything which impairs his usefulness in the discharge of the many great and important duties imposed upon him by the Constitution necessarily impairs the operation of the government. Judicial Department. Requisites for judicial inquiry. No question involving the constitutionality or validity of a law or governmental act may be heard and decided by the court unless there is compliance with the legal requisites for judicial inquiry. Namely, A. There must be an actual case or controversy calling for the exercise of judicial power. B. The person challenging the act must have the standing to question the validity of the subject act or issuance. C. The question of constitutionality must be raised at the earliest opportunity. And D. The issue of constitutionality must be the very least moda of the case. Samahan ng mga Progresibong Kabataan or Spark et al. Versus Quezon City. Actual case or controversy. The established rule is that courts of justice will take cognizance only of controversies wherein actual and not merely hypothetical issues are involved. The reason underlying the rule is to prevent the courts, through avoidance of premature adjudication, from entangling themselves in abstract disagreements and for the court to be satisfied that the case does not present a hypothetical inquiry or a claim contingent upon some event that has not and indeed may never transpire. Senator Leila de Lima et al. Versus Honorable Juanita Guerrero, TR 229781, October 10, 2017. Ripeness. A question is ripe for adjudication when the act being challenged has had a direct adverse effect on the individual challenging it. For a case to be considered ripe for adjudication, it is a prerequisite that something has then been accomplished or performed by either branch before a court may come into the picture, and the petitioner must allege the existence of an immediate or threatened injury to himself as a result of the challenged action. He must show that he has sustained or is immediately in danger of sustaining some direct injury as a result of the act complained of. Spark et al. Versus Quezon City. The question of locus standi or legal standing focuses on the determination of whether those assailing the governmental act have the right of appearance to bring the matters to the court for adjudication. Petitioners must show that they have a personal and substantial interest in the case, such that they have sustained or are in immediate danger of sustaining some direct injury as a consequence of the enforcement of the challenged governmental act. When those who challenge the official act are able to craft an issue of transcendental significance to the people, the Supreme Court may exercise its sound discretion and take cognizance of the suit. The court may do so in spite of the inability of the petitioners to show that they have been personally injured by the operation of a law or any other government act. This is a case of first impression in which the constitutionality of juvenile curfew ordinances is placed under judicial review. Generally, abandoned doctrines of the Supreme Court are given only prospective effect. However, a strict interpretation of this doctrine, when it causes a breach of a fundamental constitutional right, cannot be countenanced. Spark et al. Versus Quezon City. Political question. The issue of allowing Marquez burial at the libingan ng mga bayani involves a truly political question which is within the full discretionary authority and wisdom of President Duterte to decide. If the grant of presidential pardon to one who is totally undeserving cannot be set aside under the political question doctrine, the same holds true with respect to the President's power to faithfully execute a valid and existing AFP regulation governing the LNMB as a national military cemetery and military shrine. More so, even if subject to review by the court, President Duterte did not gravely abuse his discretion when he allowed Marquez burial at the LNMB because it was already shown that the latter is qualified as a Medal of Valor awardee, a war veteran, and a retired military personnel, and not disqualified due to dishonorable separation or reversion or discharge from service or conviction by final judgment of an offense involving moral turpitude. If grave abuse is not established, the court will not substitute its judgment for that of the officials concerned and decide a matter which, by its nature or by law, is for the latter alone to decide. Saturnino Ocampo et al. Versus Real Admiral Ernesto Enriquez et al. GR numbers 225973, 225984, 226097. Constitutional Commission's Civil Service Commission. As an exercise of political discretion, the appointing authority is afforded wide latitude in the selection of personnel in his department or agency and seldom questioned, the same being a matter of wisdom and personal preference. In certain occasions, however, the selection of the appointing authority is subject to review by Respondent Civil Service Commission, CSC, as the central personnel agency of the government. The only function of the CSC is merely to ascertain whether the appointee possesses the minimum requirements under the law. If it is so, then the CSC has no choice but to attest to such appointment. Aurora Cirillas versus Civil Service Commission et al. GR 180845. In instances of reorganization, there is no encroachment on the discretion of the appointing authority when the CSC revokes an appointment on the ground that the removal of the employee was done in bad faith. In such instance, the CSC is not actually directing the appointment of another, but simply ordering the reinstatement of the illegally removed employee. To successfully impugn the validity of a reorganization and correspondingly demand for reinstatement or reappointment, the aggrieved officer or employee has the burden to prove the existence of bad faith. Commission on Audit. Under Section 26 of the Government Auditing Code of the Philippines, only the Commission on Audit, COA, has the jurisdiction to settle claims of any sort against the government. Hence, the back payment of any compensation to public officers and employees cannot be done through a writ of execution. Republic versus Honorable Luisito Cortez, GR 187257. Rule 2, Section 1, Letter B of the 2009 Revised Rules of Procedure of the Commission on Audit specifically enumerated those matters falling under COA's exclusive jurisdiction, which include money claims due from or owing to any government agency. Rule 8, Section 10, Letter A further provides that COA shall have original jurisdiction over money claims against the government, among others. In this case, the petitioner's money claims, which were only filed with the DPWH in 2004 or even in 2001, had already prescribed. The petitioner's money claims have prescribed and are barred by laches for their failure to timely file the petition with the COA. Madag Buisan et al. Versus Commissioner on Audit. The Commission on Audit, COA, is endowed with enough latitude to determine, prevent, and disallow irregular, unnecessary, excessive, or extravagant or unconscionable expenditure of government funds. It is tasked to be vigilant and conscientious in safeguarding the proper use of the government's and, ultimately, the people's property. The exercise of its general audit power is among the constitutional mechanisms that gives life to the check and balance system inherent in our form of government. Money claims and judgments against the government must first be filed with the Commission on Audit. Trial courts have already been strongly cautioned against the issuance of writs of execution in cases involving the disbursement of public funds in Supreme Court Administrative Circular No. 10, 2000. Miscellaneous Provisions. Section 3, Article 12 applies only to lands of the public domain. Public lands are therefore outside of the prohibitions and limitations stated therein. Section 3. Lands of the public domain are classified into agricultural, forest or timber, mineral lands, and national parks. Agricultural lands of the public domain may be further classified by law according to the uses which they may be devoted. Alienable lands of the public domain shall be limited to agricultural lands. Private corporations or associations may not hold such alienable lands of the public domain except by lease for a period not exceeding 25 years, renewable for not more than 25 years, and not to exceed 1,000 hectares in area. Citizens of the Philippines may lease not more than 500 hectares or acquire not more than 12 hectares thereof by purchase, homestead, or grant. The Republic argues that the trial and appellate courts erred in granting respondents RRDC's application for the registration of the subject land, as the same has a total land area of 31.8 hectares, which is way beyond the 12-hectare limit under Section 3, Article 12 of the 1987 Constitution. Republic versus Rovensi Realty and Development Corporation. Section 15, Article 14 of the Constitution, which deals with the subject of arts and culture, provides that the state shall conserve, promote, and popularize the nation's historical and cultural heritage and resources. Since this provision is not self-executory, Congress passed laws dealing with the preservation and conservation of our cultural heritage. One such law is Republic Act 166. or the National Cultural Heritage Act of 2009, which empowers the National Commission for Culture and the arts and other cultural agencies to issue a cease and desist order when the physical integrity of the national cultural treasures or important cultural properties is found to be in danger of destruction or significant alteration from its original state. Physical integrity refers to the structure itself, how strong and sound the structure is. The same law does not mention that another project, building, or property, not itself a heritage property or building, may be the subject of a cease and desist order when it adversely affects the background view, vista, or sight line of the heritage property or building. Thus, Republic Act 10066 cannot apply to the Torre de Manila condominium projects. Knights of Rizal versus DMCI Homes, GR 213948. Local government. It is an elementary principle that a municipality has a personality that is separate and distinct from its mayor, vice mayor, sanggunian, and other officers composing it. Under no circumstances can this corporate veil be pierced on purely religious considerations without running afoul the inviolability of the separation of church and state enshrined in the Constitution. In this case, the Sharia District Court had no jurisdiction under the law to decide private respondents' complaint because not all of the parties involved in the action are Muslims, since it was clear from the complaint that the real party defendant was the municipality of Tangkal. The Sharia District Court should have simply applied the basic doctrine of separate juridical personality and motu proprio dismissed the case. The municipality of Tangkal, province of Lanao del Norte versus Honorable Razad Balindong et al. In furtherance of the state's policy to foster genuine and meaningful local autonomy, the national legislature delegated the exercise of police power to local government units as agents of the state. Such delegation can be found in Section 16 of the Local Government Code, which embodies the General Welfare Clause. Since LGUs exercise delegated police power as agents of the state, it is incumbent upon them to act in conformity of the will of their principal, the state. Necessarily, therefore, ordinances enacted pursuant to the General Welfare Clause may not be subvert the state's will by contradicting national statutes. In another way, municipalities are precluded from regulating conduct already covered by a statute involving the same subject matter. In this case, the assailed ordinance enacted by Batangas City effectively contravenes the provisions of the Water Code as it arrogates unto Batangas City the power to control and regulate the use of groundwater, which by virtue of the provision of the Water Code pertains solely to the National Water Resources Board, WRB. City of Batangas versus Philippine Shell Petroleum Corporation, GR 195003, June 7, 2017. While police power is lodged primarily in the national legislature, Congress may delegate this power to local government units. An ordinance constitutes a valid exercise of police power if a. it has a lawful subject such that the interests of the public generally, as distinguished from those of a particular class, require its exercise, and b. it uses a lawful method such that its implementing measures must be reasonably necessary for the accomplishment of the purpose and not unduly oppressive upon individuals. Once delegated, the agents can exercise only such legislative powers as are conferred on them by the national lawmaking body. In this case, RA 4354, otherwise known as the Revised Charter of the City of Davao, enacted on June 19, 1965, vested the local Sangguniang Panglungsod with the legislative power to regulate, prohibit, and fix license fees for the display, construction, and maintenance of billboards and similar structures. With the aforementioned law, Congress expressly granted the Davao City government, through the Sangguniang Panglungsod, police power to regulate billboard structures within its territorial jurisdiction, which it did through the Sangguniang's issuance of Ordinance Number 092-2000. Honorable Leoncio Evasco Jr. et al. Versus Alex Montañez, GR 199172, February 21, 2018. In order for an ordinance to be valid, it must not only be within the corporate powers of the concerned LGU to enact, but must also be passed in accordance with the procedure prescribed by law. The ordinance must 1. Not contravene the Constitution or any statute. 2. Must not be unfair or oppressive. 3. Must not be partial or discriminatory. 4. Must not prohibit but may regulate trade. And 5th, must be general and consistent with public policy. And 6, must not be unreasonable. City of Batangas versus Philippine Shell Petroleum Corporation, GR 195003, 2017. The privilege of operating a market stall under license is always subject to the police power of the city government and may be refused or granted for reasons of public policy and sound public administration. Being a delegated police power, falling under the General Welfare Clause of Section 16 of the Local Government Code, the grant or revocation of the privilege is therefore discretionary in nature. Rodolfo and Willie Lego versus Municipal Mayor of Solano, Nueva Vizcaya, GR 188448. Any issue as to boundary dispute may be resolved by referring the same to the province's respective Sangguniang Panlalawigan, following Section 118 of the Local Government Code, which provides for the remedy in case of a boundary dispute. Section 118. Jurisdictional responsibility for settlement of boundary dispute. Boundary disputes between and among local government units shall, as much as possible, be settled amicably. To this end, a. Boundary disputes involving 2 or more barangays in the same city or municipality shall be referred for settlement to the Sangguniang Panlungsod or Sangguniang Bayan concerned. B. Boundary disputes involving 2 or more municipalities within the same province shall be referred for settlement to the Sangguniang Panlalawigan concerned. C. Boundary disputes involving municipalities or component cities of different provinces shall be jointly referred for settlement to the Sanggunians of the provinces concerned. 4th, boundary disputes involving a component city or municipality on the one hand and the highly urbanized city on the other, or 2 or more highly urbanized cities, shall be jointly referred for settlement to the respective Sanggunians of the parties. And 5th, in the event the Sanggunian fails to effect an amicable settlement within 60 days from the date the dispute was referred thereto, it shall issue a certification to that effect. Thereafter, the dispute shall be formally tried by the Sanggunian concerned, which shall decide the issue within 60 days from the date of the certification referred to above. In this case, the boundary dispute is between the municipality of Alfonso Lista in the province of Ifugao and the municipality of Ramon in the province of Isabela. GR 198647, November 20, 2017. Part 3 will be uploaded right away, so if you're not yet subscribed to our channel, go ahead and hit that subscribe button and let's study together. Thanks.